Good evening. Welcome. I'm Rudolph D'Souza, your host on today's webinar by MyNation Hope Foundation. Thank you for being with us today. We appreciate joining us on every Sunday on different topics and Mann Ki Baat. Today we are talking about a special person, our guest. He has unique case, which no media is ready to publish. They are mostly publishing only women stories. That's why we started Mann Ki Baat. So on our Mann Ki Baat, we'll talk about men's problem, how they are harassed by law, how they are victimized by our system. That's what we want to show in our Mann Ki Baat. Please watch our weekly Mann Ki Baat. I welcome Mr. Manmohan Mittal to Mann Ki Baat. He is from Shamli, Uttar Pradesh. Welcome, Mr. Manmohan Mittal. Please introduce yourself. Hello. Hello. Mittal, are you there?
Hello. Yes, I'm sorry. There was some problem with my connection. I'm sorry. Yes, I'm here. I'm sorry about that.
Yeah, please introduce yourself.
Okay. Hello, everyone. My name is Manmohan Mittal, and I'm working I'm 44 years old, and I'm working in a MNC in Gurgaon. It's an IT company, and I have just joined MyNation like 6-7 months before. And I also came to know about SIF around 1 year before. So this is the background. Yep.
Okay. Who filed a case on you? And which case filed?
Okay. The thing is, since I said, I was not attached to any organization before. So the first case was, on the advice of one of my college friend, I filed a divorce case first. And then after she started filing counter cases, all packages, everything.
No, why you filed divorce case?
Yes, actually, since I was not trained, I didn't know anything about anything. And my advocate advised...
There should be some reason, no? Like she was harassing you, or she was not treating as per the not cooking or something like that. If she is a housewife,
okay,
our marital duties.
Yes, actually, I will give you a little background because
I'm divorce also. There should be some ground, right?
Yes, of course, sir. So actually, the thing is, I'm married in my marriage was done in 2003. So I'm almost married for 18 years now. I have two daughters, 17 and 9. And there were a lot of things happening for last one. Like things started in 2016, and a lot of things were happening. We were not happy. This and that. She was not working for 15 years. She started doing job without my permission. So the things started getting nasty. So in 2018 January. We had a panchat where all the relatives of 10 relatives of mine and then 10 relatives of her joined the meeting, and she said, you are doing this, you are doing that. I agreed to everything that okay, I will try to improve myself. She says, you drink, okay, I will not drink, but she did not listen to anything, and you said, I want divorce. Okay, and also she wanted she asked for divorce in the meeting. Yes. And also, she actually was prepared. She came prepared for that meeting, and both of the kids, she prepared everything that what you have to say. Kids were also on her side, and she said, "I want divorce," and asked rupees 2 crore from me towards maintenance and everything.
Okay. No, but what made her to join to start working?
Well, she had some financial, she was an influence of her family, and her brother, advised her to join the job because she was feeling. I don't know why. What was the reason exactly? But she was under influence of the her.
Yeah, whatever influence, as you said, without your permission, it's not like she is like subordinate. It's not like that. She should not ask your permission. It's a both. It should be like if she is paying the half of the expenses when she is working, it should be mutual.
Yes,
Marriage is
yes,
not like someone is superior, someone is inferior. It's not like that. Both should go hand in
exactly,
hand. It's like two wheels of the same car. Okay.
exactly.
And if she is ready to pay half of the expenses when she is working, then it's okay. You pay half, I'll pay half. It should be like that. But most of the time,
Exactly.
when they start working, they will not pay anything, and you have to pay as you are paying from beginning. Okay, still they will
Exactly. So
claim maintenance. Even they are working, they will claim for maintenance. That is other
yes,
thing.
yeah.
Okay.
So
And you
that's what
said
that is
after
the what
you
I was.
filed, yeah.
So just would like to add one more point because the thing getting started in ST because she was working, she was earning around 35,000 rupees, and she was not ready to pay even a single rupee in household things.
Okay.
So
Yeah.
she wanted to me to pay all the bills. She did not want to talk to me. She only wanted to
No,
maintenance of
that is
everything.
normal. Even woman
Yeah.
organizations promote that one. They will say, "Oh, what is hers only. What is husband's also hers only." No, that is the
Yes.
normal trend of our feminist organization. They will promote that one. Tomorrow, if we tell that also, they will support her only. Okay, it's her
Yes.
money.
Yes,
Why
sir.
you want her money? Okay,
Yes.
you cannot challenge. If they will say it's her money, she can give it to anyone. But they will not tell, okay, spend for your house, this your family, your marriage, your kids, spend for them. They will not tell that. It's her money, let her do anything. That is the attitude of our women organization. Anyway, when she filed other cases, she filed on any other family members or only on you?
Yes, sir. She included first she filed complaint in the women's cell, which included me and my five family members, my mother, father, my bhaiya bhabhi, and my sister.
Okay.
So
That means
yes,
she filed all these cases. There was no ground to file. She filed in a revenge for your divorce, right?
exactly, exactly.
Okay. Okay. How long you been married? 18 years? 19 years?
Yes, 18 years now, sir.
Okay. Okay. And she was like when she came to that divorce counseling or wherever with the family members,
Mhm.
she claimed that you coming home drunk, beating her, demanding dowry, and blah blah, all the stories. What?
Exactly, sir. She cooked all the story, and she came prepared with the 18 pages of complaint, and
Mhm.
she has been written that I am being tortured for last 15 years. Not today. I'm being tortured since last 15 years, and there were no
Mhm.
complaints, nothing, no FIR, no even no call to a 100 number or nothing like that. So because nothing
Okay.
happened, so nothing was there. No MLC, nothing.
No, no,
So it's all
that is
cooked
all
up.
false. They will claim just to claim maintenance. They will say I was tortured from the beginning. They will tell like
Yes,
that only. But
yes, yes,
then again, they have other story also. Even someone is asking her, why didn't you complain? Then no, no, I wanted to save my marriage. Okay, they will
exactly.
cry. They will say there is no bone in tongue, so they can twist anyway. Okay, whenever the things when you say here, they will say, no, I wanted to save my marriage. That's why I didn't file. Now I cannot bear that the torture is so much. That's why I'm filing. And in
Yes,
counseling, she is saying she is demanding divorce. Then she will say, you file the divorce first. She is demanding his husband duty. Whatever her wife is demanding is giving to her is husband duty. Now you are doing your duty, whatever she is asking. Now she will claim saying You filed the divorce. That's why I am filing all the false cases.
Exactly, sir. And
She can
one
twist
more.
her tongue any way she wanted. Yeah, tell me.
Yes. Yeah, one more point I would like to add here, sir. She's living in my house. We were living, together in last. And, I was stepped out. I was forced to step out from my own house. And she has all the jewelries, everything she has. Even my clothes are even still there. And she's staying in my house, and I can't visit. I can't go there. I can't talk to my children like that.
Okay. Okay. Yeah, that's what they are doing. But you complained to police?
Yes, I did. And they said, "Oh, this is a." Their response was like, "Okay, is this your own house or rented out?" I said, "Rented out." Well, they said, "Okay, we can't do anything. This is a rented house, and if it could have been your house, then we could have helped you." And they said, "No, we can't do much about it." Even
it's your house, they will not do anything. Okay, we know very well. Many of our other members are out of their own hard-earned property and house. Okay, and some are even the parents, old parents, are kicked out from their own house. And there are judgments also. Woman has more power than even the Senior Citizen Act or whatever. They are making laws for them, but there's a useless laws. They will not help any old parents or anyone. Anyway, police did no inquiry or nothing, right?
So this is when I filed a complaint with the police, they did not do any inquiry, yes. But after she filed a 498A case, FIR, then they did some inquiry and they did help me. They investigated the case, and actually, because there were two sections involved in that case, maybe you're aware, 313 and 377. So because of those two sections, the case was transferred from main police station to Mahila police station, Mahila Police Thana.
Okay.
So there were two IOs of the case. One at the main police station, and the other one was on the Mahila Police Thana. So their case was investigated. They took my all the statement and everything. I tried to convince them, and they decided to remove all the names, like my parents, my Bhaiya Bhabi, and my sister. Also, they decided to remove the sections 377 and 313.
Which is Delhi police?
No, sir. The cases are in Faridabad, Haryana.
Haryana. Okay. For that they done a good job. Then we are thankful to Haryana police.
Yes.
It's not like we are always blaming police, but there are some very few police. They are doing some good work. Thank you for helping for getting justice and not harassing innocent parents and old age parents. Anyway, how these cases impacted you and your family?
Yes, sir. These cases have impacted me and my family, in every way, economically, financially, and socially. I used to have a lot of friends, a lot of relatives. Nowadays, I don't have any friends except SIF and MyNation friends. My parents are very old. They are 75 years old. They can't even walk properly. So it has impacted a lot to my immediate family. And yes, this was a really bad experience for them.
Okay. And she claimed they gave dowry or money or something like that. She showed any financial transaction, anything like that?
No, sir. She has claimed that she has given me 5 lakh rupees. No, she demanded. She claimed that we demanded 10 lakh rupees on so and so date. So to save the marriage, he brought 5 lakhs from my father, so from her father, and give it to me, which never happened. And this was all cooked up story. There is no financial transaction.
That's what I'm saying. Whatever the 5 lakhs she's saying, is there any proof?
No, nothing.
Yeah. Okay. That means it's a totally cooked up story. There was no truth in all these cases in revenge of divorce she filed.
Yes, and one more thing I would like to add is, sir, in 490A, charge sheet was filed on June 2019, and the she has been sent notice to come and give her statement in the court, and she didn't come, and even the warrant has been issued against her. She even not respecting the even the warrant issued by the court. So she doesn't want to come because she doesn't have anything to say, no proofs, no nothing.
Okay. Okay. That means all these cases she filed just to claim maintenance or something like that, right?
Yes, sir. Yes, sir. That's correct.
Just to show that there is a cruelty, there is a dowry demand and whatever. So she can claim maintenance. So that's why she is asking 2 crores.
Yes, sir. That's correct.
Okay. Okay. And you said you have 2 daughters.
Yes, sir. I have 2 daughters. They are staying with my wife in our matrimonial house in Faridabad. And like I said, I'm not allowed to talk or
they are talking to you, or they are brainwashed and they taught against you and they are not talking to you.
See, this thing started 3 years before. So in first 2 years, I was not allowed to talk to them, and the things started. Suddenly she changed some strategy or something. In the this year in the lockdown, I started talking to my kids, but they are completely brainwashed. Little one, the younger one is actually neutral, but the elder one is actually 17 years old. She's studying class 12, and now because she will need money for her higher studies. Now she's even asking me to come down and talk to her.
When there is a money requirement, everyone is coming. It's not extra this thing. We all know when they want money, then only they were coming. Otherwise, they don't want to talk. That is normal. Exactly. That is a normal standard of all women. Whatever they are doing for money only. Even these cases she filed to claim maintenance. Anyway, is there any child visitation, or they are saying without that they came themselves, not with you approach our system, law, legal court, or nothing like that, right?
No, nothing. I just tried to contact them by the phone, and she did not pick up my phone for 2 years. Now she started picking up the phone and started, I can talk to my children, and she even offered to come down and talk to her and make some kind of deal. But she's not talking about what deal. She said, come down to here and then we will talk. I said, no, we have met 3 times in mediation center, 2 times in district court mediation center, 1 time in high court mediation center. But she offered, she only asked money like 2 crores, 1 crore, 75 lakhs, which of course is not possible for a middle class family.
You cannot count above more than 2 crores?
Yes, yes, you're correct. She don't know how counting above 2 crores. I guess so.
Okay. Okay, because when there is no chance of getting money, it will obviously count down to 1 crore, then 75 lakhs and whatever. Then at last they will say, whatever you wanted to give. They will not agree for that because the women organization will prompt them. No, you ask this much. You ask for house and this thing, that thing. Oh, you have 2 daughters. For daughters also you can claim. They will misguide her. Because our women NGOs main job is breaking a family. No one will come to unite a family. Okay, there is some problem with this family. Let's unite them. Let's solve their personal problem, personal issues, personal egos. No, not a single woman NGO will come forward to unite. Stop a breaking family breaking this thing. No, not a single woman NGO will do. They will promote, prompt, support, guide, and give all the support for them to break the family. That's what all the women NGOs are doing. Anyway,
exactly, sir.
That's what that everyone knows. In this situation, any of your friends family came to your help, or how they responded to this situation?
Yes, sir. I would like to add here that my immediate family, like my brothers and my parents, are actually with me in this difficult time. But apart from that, none of the friends. I know at least 100 people in Faridabad, and no one was available when I needed a jamanati for my bail. It took
Mm-hmm.
me like several days to to arrange for a jamanati. You know that we need a person.
Mm-hmm.
So
Yeah, yes,
I could
yes.
not even my even my my colony people, my landlord, nobody was even ready to talk to me. So apart
Mm-hmm.
from my immediate family, nobody helped me. Yes.
Yes. So when you have a problem, no one will come. When you wanted a bail and no one is ready to give the surety, that is happening. It's
Yes.
nothing new in that. When you are happy, when you are giving something for free, everyone will come. When you are happy, enjoying, they will come and enjoy with you, enjoy your money. But when you are in a problem, no one will ask you. That is the normal trend of
Exactly.
our today's society. Okay, no one will listen you. Why 95,000 men are committing suicide? Not because of the this thing, because of the society bias attitude towards men that make them, that push them to commit suicide. There is no option left for them. They will take last option or whatever left for them. Even our government is ignoring our voice. We are telling for decades now. They are acting blind, deaf, and dumb. They have no voice against this feminist mafia. What they are doing in India, they are destroying our society. They are breaking our family and marriages. Tomorrow, our India will be, I can say, fatherless kids. That's what we will see in next within a decade. Anyway, I have a last question for you. Uh, how come you came across My Nation Hope Foundation?
So I came across because I joined SIF first, and from there I came through internet about MyNation and joined this WhatsApp group.
Okay. You got any help from us, or you just wanted to show that you are a member of My Nation?
No, I've received a lot of help and a lot of questions. My questions were answered when whenever I needed help. Everybody is very helpful in the group, and in fact, but unfortunately, I could not receive help when I actually needed the help at the time of my bail and all those things. I filed the divorce case first, which I should have I have not done it.
Okay.
So I learned these things now, and I really hope the new people who are actually new fighters. I hope they don't repeat the mistakes I've done.
Okay. You have any message to our system, our politician, our society?
Yes, yes, of course,
Yeah,
sir.
please.
I have a message for at
Yeah.
least for new fighters that at least first of all they need to be calm. They need to be strong, and you need to take care of your parents and yourself. And I would like to say something about little bit about mental health because what I've seen, many of the people actually after filing the cases, they get into the depression and all those things. They are not able to handle the pressure, and even a lot of men are doing suicide because of these fake cases. So I would suggest, I would recommend all of the people who are new joinee, please take help from the help from the group members. They are very they are very experienced. Follow their guidelines, follow their advice, and be calm, be strong, and be safe. Yes.
Okay. Thank you, Manmohan Mittal, for being with us, for your spending time with us. Thank you very much. I wish you all the
Thank
best.
you.
Hope you will overcome your all the issues, and your daughters will be with you. Okay. I will wish
Thank you, sir.
you
Thank you.
best of luck.
Thanks a lot.
Thank you.
Thank you.
Okay. With this, we completed our Men Ki Baat. Now we will proceed with our next session about 65B, electronic evidence. Dr. Vikas Singh, please continue with next session.
Thank you, Rudy. Thank you, Manmohanji. So today we have webinar on 65B electronic evidence and the law regarding this. So the today's speaker is our beloved Dr. Sarvapalli Prasar. He is a dentist. He is also doing his final year LLB. He has a special interest in matrimonial matters and the Muslim law. So today he is going to discuss about the law regarding 65B electronic evidence. So I would like to welcome Sarvapalli Prasar to start his presentation. Thank you everyone for joining.
Thank you, Mr. Rudolph. Thank you, Dr. Vikas. Well, in this electronic age, most of our evidence will be in the form of SMSs, WhatsApp, Facebook messages. Now comes the issue. How should we submit that evidence in the courtroom? That's our topic for the day. Dr. Vikas, now, are you playing the slides or am I doing it? Or should I do it? Yeah. So this is our disclaimer. The content on this site, including pre-advice, etc., is provided by us only for your personal information and is not intended for trading purposes or for carrying out legal proceedings. Please, I would, as I always tell, you have to see whoever is watching this webinar. You have to use your discrimination, right? I mean to say, you have to use your discretion, right? Now, what is electronic evidence? See, the definition of evidence has been amended to include electronic records. Section 3 of Evidence Act. Evidence can be in oral or documentary form. The definition of documentary evidence has been amended to include all documents, including electronic records, produced for inspection by the court. The term electronic records has been given the same meaning as that assigned to it under the IT Act, which provides for data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche. So this is the definition of electronic record. Next slide, please. Admission. The definition of admission, that is under Section 17 of the Evidence Act, has been changed to include a statement in oral, documentary or electronic form, which suggests an inference to any fact at issue or of relevance. Section 22 of Evidence Act has been inserted into the Evidence Act to provide for the relevancy of oral evidence regarding the contents of electronic records. It provides that oral admissions regarding the contents of electronic records are not relevant unless the genuineness of electronic records produced is in question. So just say, let's say, recording or a WhatsApp message or a Facebook message or an email. It's not enough to say, yes, I received an email, or if the opposed party can't say that I have received an email. That's not enough. Let me repeat this. Oral admissions regarding the contents of electronic records are not relevant unless the genuineness of electronic records produced is in question. Next slide, please. Electronic record. Electronic record is a documentary evidence under Section 3 of Evidence Act. Taking and recording evidence would assume great significance in administration of justice. Electronic record is documentary evidence under Section 3 of Evidence Act. What is an electronic record? An electronic record may be like computer printout, compact disc or video compact disc, pen drive, chip, etc. as was observed in Bodala Murali Krishna versus Srimati Bodala Pratima. And this is the citation, 2007, volume 2, ALD 72. Examination of witnesses in criminal cases through video conferencing was approved by the Supreme Court in a judgment and reported in State of Maharashtra versus Dr. Praful B. Desai. 2003, volume 2, ALT, Criminal Journal, 118, Supreme Court. Next. Cell phone record. Evidentiary value. Understand this. Cell phone or mobile phone recording is a valuable piece of evidence, because even see, taking 498 into perspective, before the opposite party files the 498, you will definitely get threats. You will get hints that, boss, we are filing a 498. We'll file cases on you. We'll file false cases on you. Use it, or use those records. Record those calls and use it to your advantage. It's a good defense strategy. Right. In state of Delhi versus Navjot Sandhu versus alias Afzal Guru, Apex Court, while considering the printout of computerized records of the calls pertaining to cell phones in view of the production of electronic record, held as follows. Irrespective of compliance with the requirement of Section 65B, which is a provision dealing with the admissibility of electronic records, there is no bar to adducing secondary evidence under the other provisions of the Evidence Act, namely Section 63 and 65. It may be that the certificate containing the details in subsection 4 of Section 65B is not filed in the instant case, but that does not mean that secondary evidence cannot be given, even if the law permits such evidence. Circumstances mentioned in the relevant provisions, namely Section 63 and 65. Any questions? Any doubts? Any questions? Any doubts? Next slide. Am I audible? Am I audible? Yeah, thank you.
Yes.
Section 63 of Indian Evidence Act. Secondary evidence. Secondary evidence. What is secondary evidence? Secondary evidence means and includes certified copies given under the provisions hereinafter contained, copies made, so certified copies of court documents or certified copies of evidence, they are secondary evidence. Number one, copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy, and copies compared with such copies. Copies made from or compared with the original. Counterparts of documents as against the not execute them. Oral accounts of the contents of a document given by some person who has himself seen it. Oral account of a document by somebody who has himself seen it. Next. 63 of illustrations. A photograph of an original is secondary evidence of its contents, though the two have not been compared, if it is proved that the thing photographed was the original. A copy compared with a copy of a letter made by a copying machine is secondary evidence of the content of the letter, if it is shown that the copy made by the copying machine was made from the original. So this talks about the admission of a Xerox copy. A Xerox copy is admissible only not as a primary evidence but as a secondary evidence. A copy transcribed from a copy but afterwards compared with the original is secondary evidence, but the copy not so compared is not secondary evidence of the original, although the copy from which it was transcribed was compared with the original. So when you are submitting a Xerox, if you want, you can submit the original document, or if you don't want to submit it, show it to the court and take it back, saying that you need it for something else or something of that sort. Right? Next slide, please. Neither an oral account of a copy compared with the original nor an oral account of a photograph or machine copy of the original is secondary evidence of the original. Comments. Admissibility application moved for permission to read secondary evidence based on ground of loss of document. Presence of document proved from the facts pleaded. Allowing secondary evidence is not illegal. Shobha Rani versus Ravi Kumar. Tape recorded statements are admissible in evidence. K.S. Mohan versus Sandhya Mohan. Certified copies of money lenders licenses are admissible in evidence. K. Shivalingaya versus B.V. Chandrasekhar Gowda. Next. Section 65 of Indian Evidence Act. Cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition, or contents of a document in the following cases. When the original is shown to be in the possession of or power of the person against whom the document is sought to be proved, or of any person out of reach of him, or not subject to the process of court, or of any person legally bound to produce it, and when after the notice mentioned in section 66, such person does not produce it. So what does it mean? Let's say the opposite party has some documents, but you have just a Xerox copy of it. You have the secondary copy of it, right? You have the Xerox copy of it, so you can submit it and then tell the court, my lordship, the document is in possession of the opposite party. So there are two options. You can either ask the court summon that document, or or then you can say that this is secondary evidence. Choice is yours. Right, number one. Number two, when the existence condition of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest. When the original has been destroyed or lost, your phone is lost or your phone is destroyed, what do? You will admit it along with the 65B. You will submit the printouts along with the 65B. Or when the party offering evidence of its contents, for any reason not arising from his own default or neglect, produce it in reasonable time. When the original is not of such a nature as not to be easily movable. Next slide, please. When the original is a public document within the meaning of section 64 of Indian Evidence Act. When the original is a document of which a certified copy is permitted by this Act or by any other law in force in India to be given in evidence. When the original consists of numerous accounts of other documents which cannot conveniently be examined in court, and the fact to be proved is the general result of the whole collection. That's it. In cases A, C, and D, secondary evidence of the contents of the document is admissible. In case B, the written admission is admissible. In case E or F, a certified copy of the document but no other kind of secondary evidence is admissible. Certified copy of the CRPC 161 statement is secondary evidence because as per section 74 of Indian Evidence Act, CRPC 161 statement is a public document. Right? In case G, which is when the original consists of numerous accounts or other documents which cannot conveniently be examined in court, and the fact to be proved is the general result of the whole collection. In case G, evidence may be given as to the general result of the documents by any person who has examined them and who is skilled in the examination of such documents. Okay. Next slide, please. Admissibility of telephone call in a CD or admissibility of a telephone call in Jagdev Singh versus the state and others. Honorable High Court of Delhi, while dealing with the admissibility of intercepted telephone call in a CD and CDR, which were without a certificate under Section 65B of Evidence Act, the court observed that secondary electronic evidence without certificate under Section 65 of Evidence Act is inadmissible and cannot be looked into the court for any purpose whatsoever. Next slide, please. Admissibility of email in Abdul Rahman Kunji versus State of West Bengal. Honorable High Court of Calcutta, by deciding the admissibility of email, held that in email downloaded and printed from the email account of the person can be proved by virtue of Section 65B, read with Section 88A of Evidence Act. The testimony of the witness to carry out such procedure to download and print the same is sufficient to prove the electronic communication. Let's say you received an email and you want to submit it as an evidence. Very simple. Write that you received the email from so and so person, from so and so email ID, and then you own the laptop. The email is downloaded in your laptop, and then you took a printout. That's enough. Next slide, please. Anwar versus Bashir.
Yes, can you take some questions?
Yes, I can.
Okay. Uh, hello.
Ramesh is not here, so I will take the question. So the first question came with brother and she now filed, means like I think wife brother, and the wife has filed 498A 34 DP Act and 323. The 10 years with married life, means the married life of 10 years. My phone is with her. Whether I have to admit that it is my voice or not in the phone, I think in phone recording. Please guide me what I have to do.
Question number thing one. I would ask him to rather talk with me in person. That's better. But what I say is, but opposite party, not him.
Hello, Prasar.
Yeah, am I audible?
Yeah.
See, the point is, burden of proof is on the opposite party, not him. Why should he admit?
Okay.
No, that
Next question is
not clear. Not clear what he is
Oh.
saying. Voice is his. That means she is making a call to someone and saying, "I am like," or someone, her brother is talking and saying, "This guy is making a call." We don't know the actual situation, what he is asking. That's why I asked what he meant by brother and wife. One is with her, wife is mine. His question is not correct. Let him, if he is there in MyNation, he can ask in group. Otherwise, let him correct the question and post it again so we can answer.
Okay. The second question is, sir, what are the judgment for voice and sound interaction between, means there's a recording between husband and wife, and the wife I think used in that recording in divorce case, so that no privacy issue comes under Article 20 and 21. That wife was not aware was not aware as the interaction recorded, means the he has recorded the interaction, means the chat with the voice chat between the husband and wife, and he want to use it in the divorce case. So there should be
What does he want? What is
he want to use in a divorce case, and he's want to ask he that the wife can be used as a under Article 2021, that this evidence cannot be used.
See, there are two. See, his question is not clear. Let me give you two versions. Let's say he wants to take refuge in Article 21, violation of right to privacy. There is a judgment of Andhra High Court which is on MyNation. I don't remember the parties. Right.
I posted one. I posted one in Yahoo, YouTube. Extramarital relation, electronic evidence in divorce. If he is related to that one, then he can refer that one. Otherwise, someone is looking for the judgment, then just go to MyNation, and there is a search window. You can search with electronic evidence or 65B or secondary evidence or whatever. You will get many judgments. If someone is asking for judgment, let them go to the MyNation. If anyone has questions, then please post it. Other than judgment.
Okay. The another question is कि one person recorded the investigation officer chat voice recording with him, and the investigation officer said कि his wife is pregnant, but the thing is कि that he and his wife is separated from many years. So now he shared that file with the family members on WhatsApp, but he lost the memory card. So the all chat are on that recording is on WhatsApp, so that he can use that as evidence.
You can use it only as secondary evidence.
Okay.
Because primary divorce is lost. Okay, he cannot submit it as primary evidence, but he can submit it as secondary evidence.
Okay. Another question is
Yes.
how to submit phone records done 3 years ago.
What does he mean by that? How to submit?
I'm not sure what his question is.
Maybe he is asking, is it valid after 3 years also valid or not? That's what I think he is asking.
Okay, as far as I know, he can definitely submit it, but I hope he has the original device.
Okay. So another question is, if the original phone is now not working and he cannot recover the data from the phone, but the person have a backup the phone call records in the laptop. So is it admissible?
Yeah, of course. He can tell the same thing.
Why to tell it's a secondary? He can say I recorded here.
That's it.
Okay. So, the another question came. RTI reply converted to wife directly in divorce case is possible. Means he obtained some RTI and he
Okay.
want to I think cross-examine wife in the divorce case. So if it possible, then he should submit that RTI reply the primary or secondary evidence. I think he want to ask.
As far as I know, RTI reply is secondary evidence. And if the
Okay.
court wants, he can summon the RTI Act, this thing also.
Okay.
The PIO also.
Okay. Another question is how to submit SMS chat conversation of a phone in court.
Take photographs, take printout,
Okay.
submit it 65B. If the court asks, he can submit the original device.
Another question is can extramarital affairs can be used in CRPC 125 Sec 4?
What does he mean? Okay, yeah, of course. But he has to prove adultery.
Yeah. Okay. Another question is the husband has saved her emails as a PDF on his laptop.
Okay.
From her email account. Means he opened the email account of wife and he saved that email as a PDF. Now the wife have deleted the emails from her email account. Now you want to ask he can use that PDF as evidence.
Does he have the URLs? If he has the URL, he has to smartly make her admit that thing. It depends on the cross examination.
Okay. Another question is from whom we should take 65B. Means he is not aware of the process how to file 65B in court. So he want to ask from whom he should take 65B certificate and how long it will take to take that certificate.
It's at the end of the webinar. Let him wait.
Okay. So another question is secondary evidence do consider or weightage is less, means the secondary evidence weightage or consideration is less than the primary, I think, from primary evidence.
Of course, boss.
Okay. Okay. That much question we have right now. We will ask if some other questions come up. You can continue. Thank you.
Judgments also related to these questions, whatever they are. Let them refer the judgment. I posted 5-6 judgments. Whatever.
Okay. In the case of CD, VCD, chip, etc., the same shall be accompanied by the certificate in terms of section 65B obtained at the time of taking evidence, without which secondary evidence pertaining to that electronic record is not admissible. Next. Amendment of IT. Love. See 65B, the previous slide or the next slide? Okay, next slide. Yeah, that's it. New sections 65A and 65B are introduced into the Evidence Act under the second schedule to the IT Information Technology Act 2000. Section 5 of the Evidence Act provides that evidence can be given regarding only facts that are at issue or of relevance. Section 136 empowers a judge to decide on the admissibility of evidence. New provision section 65 provides that the contents of electronic records may be proved in accordance with the provisions of section 65B. Next slide, please. Section 65B provides that notwithstanding anything contained in the Evidence Act, any information contained in an electronic record, that is, the contents of a document or communication printed on a paper that has been stored, recorded, and copied in optical or magnetic media, produced by a computer, is deemed to be a document, and it's admissible in evidence without further proof of the original's production, provided that conditions set out in section 65B 2 to 5 are satisfied. Next. Conditions for admissibility of electronic evidence. Before a computer output is admissible in evidence, the following conditions are set out in section 65B2 must be fulfilled. The condition, okay, 1. One is the computer output containing the information was produced by the computer during the period over which the computer was regularly used to store or process information for the purpose of any activities regularly carried on over that period by the person having lawful control over the use of the computer. Let me ask the audience a question. When you read this point, who do you think has a lawful control over the computer? I hope I get 1 or 2 replies on YouTube. Who has a lawful control over your computer?
My answer is me, if I
Yes.
have a laptop.
Exactly. Even if you have a desktop, you will have the owner of you have the lawful control over the use of your own computer. First point. Number 2. Okay, next slide, please. During the set period, information of the kind contained in the electronic record or of the kind from which information so contained is derived was regularly fed into the computer in the ordinary course of the said activities. You have a phone, you receive the email in your phone. You have a laptop, you receive the email normally in your laptop. You receive your WhatsApp web, Telegram web, WhatsApp, email. As far as you know, I don't have enough knowledge about SMS, whether you can receive SMS on your laptop. Right. Throughout the material part of the said period, the computer was operating properly, or if not, then in respect of any period in which it was not operating properly or was out of operation during that period, was not such as to affect the electronic record or the accuracy of its contents. So what we have to understand from this is that never, ever, ever, never transfer files. The moment you transfer the files, there will be a change in electronic signature. Of course, all said and done, people with better IT people from IT background can explain this better. And don't morph photos or cut photos. So if at all your evidence is sent for forensic evaluation, you lose it.
Yeah, I think we can make a copy. We cannot transfer whole copy. Means we can just make a copy, but we cannot transfer the full file and just copy, cut and paste. If we do cut and paste, then there's a new signature. The file date time will change.
Yes.
Okay.
Information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of said activities. Conditions for the admissibility of electronic evidence. Where over any period the function of storing or processing information for the purpose of any activity is regularly carried on over that period as mentioned in clause A of subsection 2 was regularly performed by computers, whether by a combination of computers operating over that period or by different computers operating in succession over that period, by different combination of computers operating in succession over that period, or in any other manner involving the successive operation over that period in whatever order of one or more computers and one or more combinations of computers. All the computers used for that purpose during that period shall be treated for the purposes of this section as constituting a single computer, and references in this section to a computer shall be construed accordingly. Next slide, please. Section 65B4. Section 65B4 provides that in order to satisfy the conditions set out above, a certificate of authenticity signed by a person occupying a responsible official position is required. Such certificate will be evidence of any matter stated in the certificate. The certificate must identify the electronic record containing the statement, describing the manner in which it was produced. See, what electronic record? Let's say there is an SMS. Let's say there is an email. So what? But the email is electronic record. How did your email come? You received an email from so and so email ID to so and so email ID, which belongs to you, and then you will say, I took a printout.
of the email. So if it is a laptop, you can say that you have a so company laptop and other details.
Give such particulars of any device involved in the production of the electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer. The certificate must also deal with any of the matters to which the conditions for admissibility relate. We have to say how this evidence is related to the case. How is it admissible? How is it relevant? Let's say there is an allegation of mental cruelty and the wife wants husband to shift to her place. What is the evidence that you give? When the wife is alleging that husband is cruel to her, wife wants husband to shift to her place. What does it mean? As per Samar Ghosh versus Jaya Ghosh, now taking Samar Ghosh versus Jaya Ghosh as a reference, you can say this email shows that wife wants husband to stay with her. Where is the mental cruelty?
Sarji?
Dr. Vikas?
Yeah, we lost you actually.
Next slide. I'm there.
Hello, sir. What, silence. You said something?
I'm there.
You are there. We know. You said something because
section 88. Nothing. I said next slide. That's it. Under the provisions of section 88A, it is presumed that an electronic message forwarded by a sender through an electronic mail server to an addressee corresponds with the message fed into the sender's computer for transmission. However, there is no presumption regarding the person who sent the message. This provision presumes only the authenticity of the electronic message and not the sender of the message. So if you understand section 88A properly, it says
There is a WhatsApp message from one number to another number.
What does it mean is you received an SMS, you received a WhatsApp from an SMS, a WhatsApp was sent or an SMS was sent from one number to the other number. That's it. It doesn't mean the person holding it has sent it. Got it?
Hello. Okay, next slide, please. R.S. Jain was the state of Rajasthan. It is held by Honorable High Court of Rajasthan that certificate as per section 65B can be produced at subsequent stage during the course of trial if it is not produced along with electronic record or along with charge sheet in the court. Next slide, please. Pravata Kumar Tripathi versus Union of India. It is held by the Honorable High Court, Orissa High Court, in the case of Pravata Kumar Tripathi versus Union of India, that at the time of consideration of bail application, it is not at all necessary to ask prosecution to first satisfy the fulfillment of all the criteria laid down in the case of Anwar versus Bashir before taking into account forensic voice examination report as well as transcription of CD. Next slide, please. Bala Saheb Gurling Totkari versus State of Maharashtra. It is held by Honorable Bombay High Court in the case of Bala Saheb Gurling Totkari versus State of Maharashtra. CDR report and electronic record. CDR report and electronic evidence is not admissible in evidence in absence of certificate as per section 65B of Evidence Act. Below is the URL. Next slide, please. K. Ramajayam versus alias Appu versus Inspector of Police. In this case, Honorable Madras High Court has issued guidelines to magistrate to follow the procedure when CCTV footage and video recording is produced by police at the time of filing a charge sheet. In this case, it is held by Madras High Court During the hearing of the case, we noticed that the trial court had not
the DVR and seen the CCTV footage in the presence of the accused. We propose to dispel misgivings, if any, in the mind of trial judges about their power to view such evidences. There will be instances where, by the time the case comes up for trial in one court, electronic record would have had a natural death for want of proper storage facilities in the property room. To obviate these difficulties, we direct that on a petition filed by prosecution, the judicial magistrate who receives the electronic record may himself view it and take a backup without disturbing the integrity of the source in a CD or pen drive or any other gadget by drawing proceedings. The backup can be kept in safe custody by wrapping it in anti-static cover and should be sent to Sessions Court at the time of committal. Below is the URL of MyNation URL. Next slide, please. Anwar versus Bashir. It is held by Honorable Supreme Court in the case of Anwar versus Bashir that an electronic record by way of secondary evidence shall not be admitted unless the requirements under Section 65.
Thus, in the case of CD, BCD chip, etc., the same shall be accompanied by certificate in terms of Section 65B, obtained at the time of taking document, without which secondary evidence pertaining to that electronic record is inadmissible. Below is the URL. Next slide, please. This is the latest judgment on electronic evidence, three-bench judgment, and this is what we have to follow now. This is a July 2020 judgment. Clarification on Anwar versus Bashir case. If an electronic record as such is used as primary evidence under Section 62, the same is admissible in evidence without compliance with the conditions of Section 65B of the Evidence Act. The clarification referred to above is that required certificate under Section 65B4 is unnecessary if the original document itself is produced. If you have an original phone which is destroyed and you no longer need it, submit the phone. If you have an old laptop, if you want to submit it, submit it. This can be done by the owner of a laptop computer tablet, or even a mobile into the witness box. And providing the concerned webinar and concerned device on which the original information is first stored is owned or operated by him. In cases where the computer happens to be part of computer system or computer network and it becomes impossible to physically bring such system or network to the court, then the only means of providing information contained in such electronic record can be in accordance with Section 65B1 together with the required certificate under Section 65B4. Next slide, please. When it comes to criminal trials, it is important to keep in mind that the general principle that the accused must be supplied all documents that prosecution seeks to rely upon before commencement of the trial under relevant sections of the CRPC. This is the URL for Arjun Panditrao Kotkar versus Kailash Bhushan Rao Gorentyal. Next slide, please. Okay, because, yeah. Templates of 65B. Somebody asked the question, how do we submit 65B? This is the answer for that. What should the certificate under Section
65B of the Indian Evidence Act contain? The certificate should 1. Describe the manner in which the electronic record was produced, furnish the particulars of the device involved in the production of the record, deal with the applicable conditions mentioned under Section 65B Clause 2 of the Evidence Act, be signed by a person occupying a responsible official position in relation to the operation of the relevant device. The person giving the certificate only needs to state in the certificate that the same is to the best of his knowledge and belief.
Next slide, please.
Now, this is the template. I know it is slightly microscopic.
This is the template. Next slide, please. That's it. Thank you. That is my email ID. That is my Twitter ID. If you have if you need further information or clarification or doubts, you can always contact me. Those in the group know me very well. So
Okay, we have
any question?
We have questions.
Please. Yeah. Okay.
So it is question from YouTube. So the question is, he want to record sound interaction between wife and husband. The husband want to record sound interaction between voice recording between husband and wife without the knowledge of wife, and want to submit that in divorce case. So he's asking if he do that without the knowledge of wife, he is recording that, and that can be used against him in the criminal proceeding.
How can it be used against him in criminal proceeding?
Means
breach of privacy. There is a judgment on that. It's a breach of privacy and breach of trust.
So he want to कि wife can file the case कि he has recorded without her consent,
Yes.
without her knowledge.
Without our consent, it will be comes on later. It will be a cruelty. So there is a judgment on that also. What law says that I don't know, but judgment says it's a cruelty. Without our knowledge, without our approval, he recorded. Now he is producing against her. That will be the cruelty and breach of privacy and whatever.
Okay. So another question is, how can we prove that the date of the photos taken? Do we need to take printouts of photo, or we can submit the photo itself, which was used to take photos? Means the device which he want to know. 2-3 questions are there. How can we prove the date of photos taken? And the second thing, what he need to submit, the printout of the photo or the device which contain the photo?
See, one thing that I would always recommend: always try to push the burden of proof onto the opposite side. You have a
Okay, you are not sure whether court will admit it or not, right? So
opposite party, confront the opposite party with that.
And in the same, it is also a question. What about photos stored in a Google Photos?
Google Photos, very simple. He will say, this is where I took the photograph. This is where I uploaded, and this is from where I downloaded. Write the whole story and then say, this is true to the best of my knowledge.
Okay. Another question is
tracking location. If it's
yes,
with his account is uploading immediately, sharing to Google Photos, then it will record the date, time, and place also.
You can check your timeline. Go for Google timeline. It will show you where you visited on that day and where you taken that photo.
Other than that, if there is a digital photo in your phone, there is a EXIF data. Okay, it's a content of the data. It will record the all the details, location itself, and which camera and what time. It's called EXIF. You can Google it. EXIF.
Yes.
Yeah, metadata. It stores everything about digital photos. Someone cannot just say, okay, this photo I'm somewhere else, and you are taking it in India. You cannot say you took it in Pakistan. It's not like that. There is a data in every digital photos.
Okay. Another question I have a video recording saved from in SD card to laptop. He saved the video recording from SD card to laptop. The SD card data has been overwritten, means that he has overwritten the SD card data. Can he use copy data, means the data he copied in the laptop, video that copied in the laptop as evidence?
Yeah, the same question came earlier, I think. Primary, whatever mobile or recorded device is lost or corrupt, now cannot be readable, but there is a copy of that on laptop which can be used or not. So that's what I'm saying. You can show that is recorded on laptop. Otherwise, you can copy back to some other mobile also, if date and time is not changed, because a matter of what is there in photo is important. Then sometimes you can check the date, time, and other things. Other than that, matter like like happy moment you spend together somewhere. Such photos that prove more details than the other evidence. If you are proving that one, then you can show that you went together for Singapore or Dubai. You can show that, see, we were happy. There was no violence or domestic violence, something. I spent money to take her abroad or for a trip. That's what you wanted to prove, not the date of photos or time of photos.
Okay. So another question is there some judgment and direction regarding chain of custody? Means about evidence.
What?
Chain of custody. Any judgment regarding chain of custody? Yeah.
It's regarding 65B or some other question?
I think chain of custody law will come soon because we have filled that law reform form. There is a chain of custody law reform.
Child custody related?
Chain of custody means some evidence are there in the custody of police, and he transferred that, means how many people can access it. When somebody access that evidence, he had to record ki, okay, this evidence is accessed by this person. Okay, so that come in a chain of custody, that have to produce in the court ki this person have accessed this evidence on this date. So that I think is not there in the laws, I think, and it will come soon. I'm not sure. Okay. Another question is, I saved a PDF of emails from her email account to us to use as evidence in okay, he was in US, so he saved the PDF of her email account in USA, and he want to use it as evidence in India. Can she file the criminal case against him?
For what?
For using the he used her email address, means he opened that email account of her and he took the PDF of emails, but he took
still admissible. There is a judgment.
The evidence is admissible, but whatever content is there in email, that can be used against her because it's her email. But again, another option comes. She can say that he hacked her email. Okay.
And he's saying
cyber police.
He's saying he accessed the email in USA, means he saved the file when he was in USA. Now he want to use it in India, so she can file the criminal case against him.
Criminal case of hacking
or some other criminal case, privacy breach of trust.
See, I will suggest
whatever happens is in US. He was in US.
Yes.
So it's not coming under Indian cyber law.
And even otherwise, even under CRPC, he can take refuge in CRPC 188. FIR will be booked, but then the opposite party has to take central government permission under section 188 of CRPC for trial.
Same person asks what precautions he need to take, what statement should he need to give in his defense.
That's why I'm telling you, don't put the burden of proof on you. Push it to the opposite side.
Okay.
Section 58 of Evidence Act states that admitted facts need not be proved.
Okay. Same person. Sorry.
Yes.
Same person asks, can she claim that it is not her email account?
Of course she can. Is there any email communication between these two parties? There will be something.
Okay. So that's much question we have from YouTube. We don't have any further questions. So I would like to suggest that everyone should subscribe this channel, because every Sunday we are doing a webinar. So you will get the notification that we are doing a webinar. And I would like to thank Rudy and Parasar sir to this wonderful webinar. So over to you, Rudy sir.
Yeah. Thank you everyone, those who joined and listened to us, and Manmohan Mittal for the Men Ki Baat, and Dr. Parasar for your wonderful presentation. Thank you very much. And those who are not member of MyNation, please register. It's free. There is no charge for anything, any questions or discussion, whatever. Everything is free. You can join. You have to just register. There is a pop-up window and follow the instruction how to register. Anyone can register. Thank you for being with us today. We'll meet next Sunday, same time. Thank you.
Thank you, Dr. Vikas. Thank you, Mr. Rudolph.